A recent ruling stating a second DUI conviction could mean losing the right to buy a firearm in Pennsylvania. Back in the spotlight tonight, Brian Wilk joining us in the newsroom with much more on this and reaction. Brian?
Sean, the question is whether or not a DUI is serious enough of an offense to strip somebody of their Second Amendment rights.
In 2016, Raymond Holloway tried to buy a firearm but was denied because of his previous convictions. In 2002, he got his first DUI in Pennsylvania. He received his second in 2005. He argued that the law does not apply to him because he is not a felon and getting a DUI is not serious enough to strip him of his rights. He sued and initially won a reversal in front of a district court. In October of 2019, his case was argued before the Third Circuit Court. On January 17th, the appeal court issued an opinion.
And what the appellate court said is, it is a serious offense. It is the sort of serious offense that the federal statute contemplated when it held that someone with a conviction of an offense punishable by more than 2 years in prison ought to be stripped of their Second Amendment rights.
The court also clarified what a serious offense could be.
What the court held was a serious crime is a crime that has the potential to cause harm to yourself or others. And the court basically held that DUI is that sort of crime.
We spoke to a gun owner who says you have the right to own a gun, but you have to be responsible.
They should. People should have a right to bear arms, but we do definitely have to draw a line somewhere. We have to. Or we'd just have, pretty soon we'd have convicted felons with firearms.
Tim George tells us that Mr. Holloway is able to take his case to the Supreme Court. Sean?
Brian Wilk in the newsroom tonight. Thank you, Brian.